document it. You said that you asked the question, and that's important. You may find that, oh, which father are you talking about? Because I have my stepfather, my real father, my sibling's father. I mean, that's common. It's common. And which one? Okay, well, which one? Tell me about each one of them. You'll get surprised sometimes about how much information there is and how many people are being left out of the situation that need to be included. So, all questions. It's hard to do. It's discipline and it's intentional to do a good job. And you're not going to be perfect. I promise. You are not. You're going to make mistakes. And you are still a volunteer who's doing this for free and is also a human being. So thankfully we can always call people back, but you also need to be open to being coached by your supervisor about spots that are missing or ways you're being biased and you don't even realize it. So I will take a minute to talk about minimum sufficient level of care. Have we talked about this yet?
First
Yeah.
day.
Okay. So we'll review it. That minimally adequate health and nutritional care, I don't know what that is, nurturance and appropriate discipline consistent with the child's physical and psychological development, is that provided by parents. When you're evaluating return to parents or to a relative or a foster parent versus a relative, or one relative against the other relative, we need to make sure everyone can meet these standards, but also when you're talking about returning to a parent, can they meet these standards? Will they have the right to their child, despite maybe a better home with a relative? So this is basically what we do, but it's very gray. And we need to make sure we're focusing on minimum sufficient level of care, because it's okay to be poor, it's okay to not have the complete support system, but it is important to have a support system when evaluating. So guidance and supervision consistent with the child's safety is able to be provided, has been shown, a safe home environment. What does that mean? It's really subjective to a point. Protection from repeated exposure to violence, even though the violence may not be directed at the child, so that's kind of talking about domestic violence. An understanding of the child's needs and capabilities, so asking a parent, if your child was in school, well, what were they studying in school? What grade were they in? That's a pretty good indicator of a child's needs. Were they in special education? Did they receive services? What does that look like? Some parents with CPS in CPS cases know a lot about their children's needs, and some know nothing. So that's an indicator of whether they're appropriate or not, and whether they can learn about them and want to learn. Whether an adequate social support system consisting of an extended family and friends is available to the child. So we've got to figure it out. How would you know, how could you speak to that if you haven't asked and haven't reached out to the family to know about it, or ask the parents about their support system? Okay, so the children and families you will be working with are disadvantaged in several ways. That goes back to disproportionality. It is of utmost importance that you do your due diligence to complete an objective and unbiased evaluation of the circumstances. You will be questioned. It is our job to question you. That's what we do. So be okay with it. And it's a conversation. We want you to challenge us too, because ideally you have more information than we do. We just want to make sure it's an objective investigation, and then help you navigate the legal system and CPS, and give you options that are available. But you're very much the expert. We just question you, as we should, as to where your information's coming from and what efforts have you made to be objective. All right? And that will help reduce bias, and it will help you on the stand too when you have to testify, that you have all your bases covered. Speaking of testifying, I'm going to do one more. So let's see, Taylor, I'm going to pick on you.
Okay.
that's really bright light. My name is Taylor Doherty. I am a court-appointed special advocate.
All right, Taylor. Let me think of a good question. Let me think. I know, usually I'm full of questions. That's easy. Okay. What was your first type of car?
My first car was a Chevy Cobalt that I got when I graduated high school because I came straight to A&M and I lived 2 hours away. So my parents wanted me to have a car in case something happened. It was it was old and hardly worked, but it was a car that ran. So.
You still have it?
Oh no, I have a Nissan Sentra now.
Okay.
So my question for you, what made you decide to leave Austin and come to Bryan to work here?
Okay, good question. So, I started here at Voices for Children 9 years ago as a supervisor, and then I went to Austin because I was attracted to their program. It was a large program, very progressive and innovative, and my family was there. So 9 years ago, my kids were babies. And so I kind of needed to go back to more of a support system in Austin. And I worked there for 6 years and worked my way up in all kinds of ways and developed programs and everything. Mm-hmm. And I really thought my 5-year plan included being an executive director because I had a lot of ideas. I'd been involved in fundraising and policy and supervision, and I really wanted the opportunity to be to kind of have control of all aspects because there were still some things I wanted to do but couldn't. So coming back, when I heard that the previous executive director was leaving, I immediately got on the phone and got some phone calls from here saying, would you be interested? And I knew coming back would be a smart decision on my part because learning a program, the Travis County program has over 50 employees. They have over 2,000 children at this point, I think, and I think a $4 or $5 million budget. So I wanted to come and learn the ins and outs of every aspect of this job of executive director. There they had a full-time person for everything, mm-hmm. grants person, communication person, Optima person, and I knew that smaller programs, CASA programs, that ED actually does a lot mm-hmm. of every aspect of it. I knew the judge was still here, Judge Delaney, and it was a supported program in the community. Mm-hmm. And then my kids were now hitting middle school. So middle school in Austin is interesting, and I had a very high stress job that kept me away all the time. And I wanted to have a better quality of life for my kids, be able to spend more time with them, and then learn every aspect of the CASA program. So committed to my kids get out of high school, and then who knows, we'll see after that. But coming back here, I think, was the best decision I could have made. I love Austin, but there's a community feel here, and this program is very solid.
So do you feel like your position here is allowing you to have that creativity that you wanted?
What do y'all think?
I say so. What do you think, Andrew?
Yes, yeah. Our board of directors is very supportive. They were interested in taking this program to the next level and growing and innovating, and so they wanted the early family engagement program. I've heard Mike talking about it, getting appointed earlier, streamlining things, saving costs by looking at all of our processes, and it has been a lot of change for the volunteers and for our staff to go through, but now we are serving 100% of the kiddos. We have largest class ever, and we're all paperless and web-based, so we'll see. Hopefully, I don't know, I'm tired of myself. Yeah, but I do have that flexibility, but it's only because we have amazing people like you and our staff that are the changes and getting on board with having really powerful advocacy. It's really exciting. I would say I am probably a little biased, but not much because I know a lot about other programs. I'm on the National Suburban Leadership Program for National CASA, where we have phone calls and CASA programs all across the nation, and we are way ahead of the curve.
Great.
Good.
Thanks, Taylor. Thanks, AJ. We're at 2 o'clock. So, well, we're at 5 after. So Kathy's up next. We're gonna do becoming an expert witness, which is what I know you were all worried about. Everybody's worried about testifying in court. But you saw, if you've been to court, you saw it's not a lot of talking, right? It's a little bit, unless we have something important to say. If it's not in the court report, we have an update, or we really disagree with somebody.
I feel like Grimes County kind of has more CASA involvement than Brazos.
Oh, so did y'all hear that? Say it again, Taylor.
Well, I've been to Brazos and I've been to Grimes County, and I feel like Grimes County has a little more CASA talking, because every case that I saw, they would specifically ask the CASA for their input, whereas, they kind of did that in Brazos County, but I feel like it's a little more involved in Grimes. Or maybe it just happens that all the cases, the CASAs needed to talk more than in Brazos, but I felt like, because I feel like Brazos County Court is a little more relaxed with like the order they talk in and things like that. It's a little more like, if the CASA feels they need to speak up, they can speak up. Whereas at Grimes, they specifically say, okay, CASA, it's your turn. What do you want to say?
Oh, that's nice. Well, Kathy will tell us more about that. So this is Kathy Lord Jones. Kathy has been an expert witness herself in, I want to say, aviation, litigation. So she can tell you a little bit about that, and has not only served as an expert witness, but is very good at investigating. Kathy was a CASA volunteer when she came in and told us the kind of things she'd been doing. We said, man, that's a great fit for being a CASA. And then she wanted to come work for us, and we were very excited. I'm not sure she's still excited, but we are. So here's your clicker, and well, thank you for being here. Sure. So I don't know if my name is Kathy, but I'm not Kathy Price. It's Kathy Lord Jones. I've been here a little over a year. My background, I was a flight attendant, sister, for 24 years for American. We lived in the Dallas-Fort Worth area. During my tenure with American, I was lucky enough that I got involved into safety work. And in the safety work, I did accident investigation. I testified with the NTSB. I worked with the FAA, so I know how to dig up stuff and then how to advocate to make it better. My whole goal was, anytime I did the safety work, it was to make it better for not only the flight attendants and the crew, but for the passengers, because you were on our airplane. And so coming here, it was kind of the next fit, where now I can apply some of that to the children that we serve. Now, as part of the expert witness, I have a second job. I work for a firm called Robson Forensic, and I am their aviation cabin safety expert. So I get called by attorneys, plaintiff, defense, I get called by insurance companies, I get called by families, and I'll look at an event that happened to them and all the facts, and then I will write a report, and then sometimes I get deposed, and sometimes I go to court and I testify as an expert witness. So I was watching, being a supervisor, and I'm watching the CASAs up there, and I can just, I know you're all going, oh God, and it's scary. I work in Grimes, Leon, and Madison. I have one judge, Judge P.K. Ryder. He must be 80, but he truly, truly loves CASA, as does Judge Delaney, and the judges in Burleson. But PK, Judge Ryder, will make a point to call on CASA. So we're always going to be standing with you, and you're always gonna have your court report with you. But when you're up there, my advice is, the first thing you do is breathe. That takes a ton of pressure off, is always breathe. And if I'm standing there with you, and I've got my notebook here, and I'm seeing you kind of doing this, I'm gonna write it down, and it's gonna be underlined, and you're gonna look at it. That's my job. But let's take this back, all right? So you're the CASA working the cases, and you're the CASA that's gotten to know this child and the circumstances in the event. In my opinion, at that point, you become the expert of that child. You are there only for the child. So I think, and I think the judges realize that, and I think the DAs realize that, is you are the expert witness when it comes to it of that child. And that is only gonna get higher, that expertise is gonna get higher and higher and higher as the case progresses. So at the adversary, like Mike said, he's appointed right away. At the adversary, he's a pseudo-expert. I mean, he knows a little, but he's done the foundation work for you to where you can take it to the next level. And you will continue to do that, working the case for the next year. That make sense?
Mhm.
Okay. So, we'll do a little of this, and I don't know how to do this. Oh, that way. Okay, so speaking in court. In Brazos, you're gonna be called, Judge Delaney may say, CASA, what do you think of this, if we're discussing an issue? He may say, CASA, do you have anything to report? Usually he's gonna call on you. Sometimes he doesn't. If you have something to say, I think you tell your supervisor and we'll get it in there. What you don't want is to say something that contradicts something in your court report. Unless what you're doing is to correct that court report on the record. In Burleson, sometimes they'll call on you, but usually they won't. If you have to interject something, talk to your supervisor, and she'll figure out a way to get it in. Okay? Grimes, Leon, and Madison, expect it. The judges like us. I can't tell you that all the attorneys do. I think you've probably heard this, but we're brand new into Grimes, Leon, and Madison, and I think I have totally rocked their worlds. Because they were being appointed as the attorney ad litem and as the guardian ad litem, so they were double dipping. Well, now CASA comes to play at the table, and we're actually working, and it's making them have to work. So they're not happy, and they've been there forever. I am slowly trying to get some of the good attorneys out of Brazos and more into Grimes, Leon, and Madison. Shh. So if you want the good ones, come. And this is what you're going to do. In a regular hearing, you're going to update the court on the child's progress. You're going to voice any concerns you have. If you were there last Wednesday afternoon, we had a hearing, and it was an adversary hearing where they had come to us and said, look, we removed the child from the mother, who was the meth head, but we had no legal grounds to remove the child from the father. And the DA had called us and said, they're not cohabitating, so we have to give the child back to the father. But we're gonna make mom do some services. We thought, we weren't big fans of mom and dad at this point, but you're like, okay, I get it. Well, then we get to court, and then we find out, well, they are living together. Oh. So, my boss is going, Kathy, did you hear that? I'm like, Sarah, yeah, I heard. Kathy, we need to. I said, hold on. So the attorneys were fighting within themselves, and you could see, and Sarah's just, Kathy, and I'm like, hold on, Judge has seen you, he knows you have something to say. And finally he said, Casa, what do you think of this? And she says, I have great concerns, and these are the reasons why. You were there. The adversary is continuing in July. He said, no, I don't agree with this at this time, I need more information. So he hears you. They all hear you. It's just how you say it, and we'll get into that. Giving praise. Always give praise. The child is doing great. His foster parents are outstanding, and mom here is working the services and doing great at the visitations and making suggestions. I'm working a case right now in Leon, and the boy is 3 and had been seriously neglected. So he's way behind on his social skills and developmental steps. And so I said, Judge, I really think he needs to get into some kind of childcare during the day, and he really needs to be tested on his developmental steps. Boom, they were ordered. But you have to be able to back it up.
So in a situation like that, who pays for the child care?
CPS.
Okay.
So trial, total different animal. If and when it gets to a trial, know that the only thing that is happening at that trial is going to be the termination of the parental rights. That's what is happening at the trial. So your trial court report is either going to say, I support termination or I don't support termination. And these are the reasons why. You will always have, at a trial, one attorney saying yay CASA and the other attorney saying boo CASA. Does that make sense? In Brazos, Delaney appoints attorneys to everybody right out of the bat. I don't know about Burleson.
I don't know.
I don't know. In Grimes, he will only appoint an attorney ad litem right out of the bat. Then if the parents come to the adversary and they say, we are totally against this, and we are indigent, and we prove indigency, he will appoint an attorney for the parents. If the parents come to court and say, we have no problem with you taking our kids, I understand I need to work services, you're not going to get an attorney until the end when we're terminating. So he spends the money a little differently than Brazos. He's very, very tight on the purse strings in the outer counties, which is sometimes a good thing and sometimes a bad thing. I don't have to fight as hard up front. I may have to at a trial, where in Brazos, I'm fighting right out of the bat, probably against the parents' attorneys. Okay? So in a trial, get ready, there's going to be one side that likes you and one side that doesn't. When you're prepping for a trial, and we will prep you, what I think is the most important thing for you to review are your court reports. Because those are your documents. That is what they can hold you to. So I would always, even when you're standing up in court with me, I'm going to hand you a copy of your court report. If you need to look at it, if there's something in there you want to reference, and I think it gives you a little more confidence, you're holding on to something. Because in court, you're standing right in front of the judge. When you're on trial, you're sitting in a box. Okay? So you're prepping for a trial, I'm going to say review all your court reports. You can also review the department's court reports. You can review the whole file. But you, in my opinion, are going as an expert witness of the child. Now, we don't have legal standing, so you're going to be called as a witness. Okay? The basic guidelines. Talk slow. I can't tell you how many times Judge Ryder has said, stop, slow down. I've got a court reporter here, and I'm old. He says he's old and he can't. So talk slow. Speak up is what AJ was saying. Direct your testimony towards the judge and the court reporter, and that's in regular court or during a bench trial. If we're at a jury trial, I want you to talk to the jury, because what you're doing when you're giving testimony is you are educating the judge or the jury about your expertise, which is the child. So you want to build a rapport with those people so that they really think that they can trust you and believe you. If you're asked a question, only answer that question. So if, AJ had just done that, I'm going to follow up with another question. Well, I'm listening to Taylor saying, what was your first car? And she said her first car, but then I think, and I know, but then after that happened, I did this. Well, you're regurgitating too much, and that's going on the docket. That's going on the court report. That's going on being taken down by the court reporter. We don't want that on there. We want just the facts, ma'am. I asked you what your first car was. That's all I want to know. If you get into it where some of the attorneys will get you down a rabbit hole, and you know you're going down that rabbit hole because you're saying, they'll say, well, couldn't it be possible? Well, didn't you know, but then could that not have happened? Would this have happened? Stop.
Too many ifs.
Back out of the rabbit hole and say, what I know is this. The rest I cannot answer. Not a problem. And we'll practice with you before trial. Think before you speak. Yes, ma'am.
My kids did love spelling bees. So one of the things that happens in spelling bees is they slow it down. The kids slow it down by saying, you're allowed to ask like 3 questions for each word, how to use it in a sentence.
Language of origin.
Origin, and I forget what the third one is, but can we, so like if somebody's directing questions like that at us, can we ask a question back at them?
You can say, I don't understand your question, can you rephrase that?
Okay, see, perfect.
That's the way I usually do it. If
Okay.
I'm starting to feel like I'm losing control,
Right.
I'll make them re-ask. And I will also tell you that depending on which attorney likes you in the trial, usually it's the DA for the department. They will get involved and see if they can slow it down too. And they can help you on redirect.
Mhm.
So it's getting to know those attorneys and that relationship. In Grimes, he is wonderful. He's a rock star, and he will not let you leave without telling your entire story.
The DA?
The DA. We haven't done a trial yet in Leon or Madison. Well, we did, but neither parent showed up, so it was by default. We'll make sure that you're as best prepared as you can be. And I always want you to breathe. And again, I'm going to write that down. When we're standing, I will write breathe. The other thing I want you to show is self-confidence. And that's kind of hard because you are nervous and people are banging questions at you. So if you remember to do all these things, you're going to show that self-confidence. So this is I don't know how to.
I'll do it.
Okay. This is kind of queer, but it gives it from a courtroom perspective. It's basically everything I said, but it's from an actual DA. And then we're going to play a game, a quick game, and I'll see how you do.
Can I ask what did you call it, a bench trial versus the jury?
Yes.
Is that just the choice of like what county, or are they different kinds of trials, or?
There are 2 types of trials. It's a bench trial, which is before the judge only. That's usually what happens. If one of the parties files for a jury trial, then it'll go to a jury. Jury trials are very expensive, so the judges will try to make them not happen.
All right.
Hmm? Is it loud? I don't know. I had earphones on.
Hello, I'm Chris Gall, Monroe County Prosecuting Attorney. Because you may be called as a witness to testify in court, I want to give you some general information about what to expect and about how to handle yourself in court. The live testimony of witnesses is the basic evidence that's heard by a jury or a judge in trial. The integrity of our justice system depends on the credibility and truthfulness of witnesses. In other words, the justice system depends on you, so we very much appreciate your participation.
He just
As
keeps
a
getting
witness in
bigger.
court, you'll be asked questions by both the prosecuting attorney on direct examination and the defense attorney on cross-examination. These questions will give you a chance to tell your story. Here are some tips to help things go smoothly. The first rule, and the most important rule, is to tell the truth. You'll be subject to cross-examination, and any inconsistencies between your testimony in court and prior statements of yourself or other witnesses will be brought out. If you tell the truth, you should be a credible witness. You should also listen carefully to every question. Don't start to answer the question until after you hear the whole question. Then take a moment and think about your answer. Then answer the question politely, speaking clearly, and loud enough for the judge or jury to hear you. Only answer the question that is asked, and then stop answering, and wait for the next question. Don't volunteer additional information that the question didn't ask. If you don't understand the question, ask for clarification. If you don't know the answer, or honestly just don't remember, don't be afraid to say that you don't know or that you don't remember. A trial is governed by the rules of evidence. Some things will be admissible into evidence, and some things won't. From time to time, the attorneys may object to a question based on the rules of evidence and ask for a ruling from the judge. When you hear an attorney object, stop talking. Let the attorney make the objection. Let the other attorney respond, and then wait for the judge's ruling. The judge will tell you whether or not to go ahead and answer the question or wait for another question. If an attorney objects, but you answer anyway, it defeats the purpose of the objection and makes it difficult for the judge to apply the rules of evidence. After telling your story on direct examination, you may be subjected to cross-examination by the other attorney. Even if an attorney seems rude or makes you angry, it is important that you stay calm and cool and don't lose your temper. Just continue to politely answer the specific question that was asked. After cross-examination, you'll get another chance to explain and clarify your answers on redirect examination. The courtroom is a formal place. Out of respect for our system of justice and for the jury, we ask that you dress formally for court. A good rule of thumb is to dress the way you would dress for going to church or to visit a relative's house on a formal occasion. This is just some general information so that you know what to expect and tips to make things go smoothly if you're called upon to testify as a witness in court. Every case is different, and you should also have an opportunity to speak with the deputy prosecutor handling your case about more specific details. They should be able to answer any other questions you may have. Again, the most important thing to remember is to tell the truth. Our local justice system depends on you, and we very much appreciate your participation and cooperation. If you have any additional questions, if you move or change phone numbers, if the defendant or someone else contacts you regarding the case and you would like advice, or if you have any other questions about what to expect in court or about your case, please feel free to contact the Office of the Monroe County Prosecuting Attorney
Don't do that.
at 349-2670.
Give him a call. I'll get it.
Thank you for your time.
Do you have more slides?
Okay.
So what was, I mean, what are you taking that away from that? What is he saying?
Don't elaborate on it.
Take your time.
Take your time.
Take your time to answer.
Mhm.
I think that people get nervous when they have to think about an answer. You don't want to take too long because everyone's watching you. So I think it's important to know that you can take your time to answer. You don't have to just immediately respond to them.
Yeah, because that's just our nature is, first of all, you don't want to be there. It's not a comfortable place. And it's not a fun situation to be in. You're talking about terminating these parents' rights, and this is, I heard a CPS person talk about, you know, the trial for the termination, and she referred it to being equal to that of someone getting the death sentence. You know, the kids are gone after that, and so, you know, it's a very serious and somber hearing. But what I find when I'm being deposed or giving testimony is, I get a question, I'm gonna count to 5 in my head. That gives everyone else in there, or my attorney, a chance to object, and let them fight it out however they're gonna go, because they will. So just, I give myself 5 seconds before I start spitting out my answer.
So I noticed in court on Wednesday, I mean, it wasn't trial or anything, but anytime Judge Delaney would ask a question to somebody, and if they waited a while, he would say, "I noticed you hesitated," and then I kind of asked them to elaborate. Is that as common in trial, or is that just a specific Judge Delaney thing that the other judges don't do, or?
You know, I'm gonna tell you, anytime you're asked to speak, if you pause and you breathe, it actually makes your brain think a little better, and your answer will probably be better. So if he says, I noticed you hesitated, you say, "No, I was just making sure I was giving you the answer that I thought was best." You know, it's easy. No questions? God, you guys want out of here, don't you? See, I'm gonna play this game and you guys already know what I'm gonna do, so it's not even fun. It'll be fun. Okay, so I'm gonna ask you a question, and I'm gonna try to get more out of you. Okay? And my name is not Mrs. Price. Excuse me, Kathy, I'm gonna come sit over here.
I want to get a look at everybody.
So, Chris Smith. Oh, hi, I know you. You came to Leon with me, didn't you? Yes. So, Chris, can you stand up for me, please?
I can.
Thank you so much. So, Chris, you know, 3 days ago, you had what for dinner?
I had Whataburger for dinner.
Are you sure?
Yes.
There's nothing wrong with saying, "I don't know," or "I don't remember." Okay? Because if by chance you didn't have Whataburger and someone saw you somewhere else, they're gonna say it, all right? Okay,
Real
you,
quick, Kathy, could we ask, like, which day are you referring to? Because I'm trying to count back what 3 days is in my head, and I can't.
yeah, you could turn around and say, thank you. You could turn around and say to me, what day specifically, because, you know, 3 days ago isn't, you can always say, can you rephrase that? Can you elaborate on that? Can you clarify that? Absolutely.
Thank you.
My pleasure. Welcome to 15.
Yeah, I was gonna say, I feel you.
Jen? Oh, hi. Hello. I've seen you in court a lot. Sorry,
I've only been there 2 times.
Okay, well, I saw you both times. So, Jen, what month did you meet your husband?
I don't know. I don't
Nice.
remember.
Oh, I wouldn't say I don't know.
I don't remember.
There. Because if your husband's sitting in the room. Right?
Oh, yeah, I know when I met my husband.
Shanna, you're just not.
Well, we tried to get married to a year to the day we met. That's the only reason I know. Isn't that sweet? We got married a year to our first date. Church was busy. She's not nearly as romantic as we are. You couldn't tell.
Okay, you can sit down. I'm not going to torture you.
Because I don't remember.
Lacey. Oh, hi. I haven't seen you in court.
She was there Wednesday, I think. Weren't you there Wednesday?
She was there in the morning.
Oh, you were there in the afternoon. That's right.
I came back in the afternoon.
She's like, yeah, she's in the back.
She's sneaky, huh? Lacey, isn't it true that it rained most of this week?
Can you clarify what you mean by
Nice.
most?
All right.
Nice. See, I mean, it seems pretty basic. You can sit down, thank you. But, you know, now that you've caught on to what I'm doing, but it's easy to say, well, yeah, you know, it rained, I think, Monday, Tuesday, Wednesday, but that wasn't the question that was asked. I don't want you to be defensive or when you're answering these questions, but I want you to give the best answer to the question that's being asked. If the defense attorney is, for the department is, and we're going with what the department is saying, say we are going for termination, he's gonna get you to eventually say the answer that he wants you to say because he knows, you two have already talked. He's read your court reports. He knows what you two are on board. If you're not on board with them, then there's gonna be another attorney that you've talked to who's gonna get you to get to that answer if you can't get it on record. So the goal is to get it on record, if it's a bench trial, and heard by the judge, or to the jury. And with the jury, you want to form an alliance with them. And the best way I found to do that is when they ask you a question, you're looking at the attorneys, and then you're not going to talk to them again until the next question. You're answering it to the jury, and you're looking in their eyes, one by one. And that's forming a relationship. And you'll know, some of them will start nodding, some of them will be taking notes, some of them will be stone cold. So just pick out who you need to work through to get more onto what you're saying onto your side. And you'll get that in time.
And I would say jury trials are uncommon for us. And we don't have a ton of trials every year. I mean, it happens. You had a few, I know Kathy's laughing at me, but it seems like more in the last year than we've had in a long time, I would say. But jury trials, not that common.
Jury trials are gonna happen if it's a big contested case. I have one in Leon, which we were appointed at in the middle, which was the stupidest thing ever. But, so we're in it now, but I've got 2 fathers, a mother, so we've got 4 attorneys, kids in foster care, foster parents that want to adopt, parents that don't want to relinquish who should, and it's going to get nothing but nasty. We're going to go to mediation next month, so hopefully we'll be able to settle something. But I'll say Judge Ryder and Judge Delaney's going to say the same thing. Before you get to a trial, he's going to look at the parents. They're going to look at the parents and say, or before a mediation even, he's going to say, it's time you put your child's best interest above your own. And that's how they're going to leave it. And you really hope that I've seen it happen. Don't give that snooker.
Dad seemed very adamant about keeping.
Yeah.
even though
But he has
does
not
keep-
shown up again for a visit.
No, he hasn't.
Mhm.
I believe in Grimes there was a father who just relinquished his rights to his daughter because he wanted her to have, she was adopted by a kinship placement, I
Yes.
think, a fictive kin, because he knew that all of the benefits she would get by being adopted, and he was willing to relinquish his rights so she could have all those benefits.
Yes.
And I thought that was really like,
Well, he also too, though, and this is actually going to trial in August. But he had said he would be willing to relinquish his rights because he knew he couldn't take care of the kids, and he also knew the benefits that the kids would get by going with this adoptive family. You know, the school, college, Medicaid, all of that, and he knew he couldn't provide that. So there are some out there. Stop snickering.
Chris you guys should go to Grimes or Leon or
I really liked
Madison.
Grimes.
Now, it's different. But, I mean, I think it's different, well, the judges are so different, and things move so differently in rural communities.
You
They're
can
just-
hear better.
Yeah, you can hear a lot better, I bet.
And he is entertaining, isn't he?
Yeah.
Did he answer his phone? That's what I wanna know.
It's a flip phone too.
In that case, the father relinquishes rights because he knew it was the better interest of the child. If you relinquish versus termination, are you still allowed to like see your kids?
No. But that would become, that is at that point, the adoptive parents' decision, once they get the kids.
because I think in that case, the adoptive family was willing to let them see
Yes.
her, yeah.
Yeah, relinquishment is not that different from termination, except you're making the decision, and you can come back later and say there are different circumstances now, and I want my kids back. But you have to hire your own attorney. It's not very likely, but it's not like and they do call it the death penalty for parents. That's it. You're done. Those kids have no parent but the state, and they are available for
Well, saying
adoption.
in that case, the father knew that it was the best thing for his kids, so there was like no bad blood between him and, you know what I mean?
Now, we
So
still
it should
need to
be-
terminate the mother.
Right,
Yeah.
but, okay.
Yeah. Yay. Do what?
You're
He was joking about it.
Terminate on the mother, I guess. Terminate her rights.
Someone over here?
I was just kind of going off of that, like, if you terminate your parental rights, but it's more of like, you know, you don't have the resources or the money to provide for the children, like, could you potentially, when you're in a better situation, come back?
You wanna talk about JMC? Well, I'm thinking that might be a situation where you might say, Grandma can raise these kids, but I want visitation.
There's several ways we've worked through some of them. There would be JMC with another family member, so you're both, one is the custodial, it's like a divorce. One is the custodial parent and the other one is the parent, and the custodial parent makes the big decisions. So there's PMC to grandma, and a case I had in Grimes, my very first case. The two boys are in foster care. So the parents gave PMC to the state, and they have parental rights, parental, they can visit,
Possessory?
Conservatorship, yeah, so they, they can follow up, they still have sibling visits with the other siblings, it's just, they're not the parent. They still have a relationship, but they're not the parent. Okay. Well, that was easy.
All right, any other questions for Kathy? Yes?
It's not so much a question in my job, which we see them all the time, because you have parents, you have a child that's like getting benefits or something. And now it's a little bit clearer to me, because we see that managing conservator and temporary conservator, we see where an aunt or a grandparent has the managing, and we see them all the time, and we sit in the office and discuss. I said, now have a little bit better idea of what's going on, because we were trying to figure out, okay, the kids aren't, but the parents still have.
There are a lot of outcomes, yeah.
Oh, we see them all the time, benefit-wise, because the kids are getting benefits, so the parent, but what we find out a lot of times as far as the adoption, some of them won't, because if they adopt, the kids will lose some of
Their
their
SSI.
benefits through Social Security, and, which are a little bit different, so, but I was trying to figure that out, because we see that so much, and it seems to happen a lot, where they have that managing and the temporary conservatorship. We were trying to figure out the difference in all those documents and stuff.
They can't make it easy.
No, it's the legal system. All right, I'm trying to decide. Should we do the activity, Kathy? We probably should. We'll do it quick. All right. No, you don't have to. Are you finished?
I'm finished.
All right. Okay, so I'm gonna hand out this value statement. This is all about bias and putting yourself, well, I'll tell you more about it. So what I want you to do is not put your name on it, okay? Do not put your name on it. That was a little double negative, wasn't it? Or something like that. I think I only gave you 3. Don't put your name on it and answer these questions. Go with your. I've got it. Oh.
How many do you have?
Only and then I want you to answer the questions. Go with your first instinct. Okay. Do not think about these. I want you to go with your gut reaction on these. All right. When you're done with it, crumple it up into a little ball. You think I'm kidding?
Fire.
They're around.
And burn. We're not going to burn it. There will be no ritual burning.
And now we need,
Happy.
hey, we need one more.
Oh, sorry. Which table? Alright. So when you get done with those, crumple it up in a little ball, let me know, and we'll put it in this bag.